Welcome to the panel on habeas corpus. My name is Kathy Mochio, and I am a visiting professor here at the Binger Center for New Americans. One of the themes and a lot of the comments that I've heard today is, wow, what do we do in this really trying time? And I'm here to give you some really good news. One of the things that the Binger Center does is to work with incredible students who become absolutely incredible advocates upon graduation and phenomenal lawyers. And so it is my distinct pleasure today to have the first ever all BCNA panel of graduates. Each of these individuals started with the center as a second-year student, became student directors in their third year of law school, and all now are litigating in federal court on federal habeas litigation. And so it's my proud pleasure to introduce Paul Demick from the American Civil Liberties Union, Mary Georgievitz at Immigrant Law Center of Minnesota, and John Bruning at Kim Hunter Law. Welcome.
Hi, so my name is Mary Georgievitz. I'm starting with an introduction, sort of an overview, a lot of numbers here, and sort of the overview of the law governing detention of non-citizens. So the budget. Since the Department of Homeland Security was created in 2003, $324 billion have been spent on the agencies that carry out enforcement. That includes, it's mostly Customs and Border Patrol and interior enforcement in ICE. The Customs and Border Patrol budget has nearly tripled in those years, from $5.9 billion in 2003 to $17.1 billion in 2019. The ICE budget has similarly increased. It's more than doubled. From 3.3 billion to 7.6 billion. Nationally, this year, ICE reached the threshold of detaining more than 50,000 people on average per day. That means in 2019, it was more than 400,000, or will be about more than 400,000 people during the year. ICE has requested funding to detain 52,000 people, so they see more room to detain more people. And there are about 160 detention centers across the country where immigrants are held. The facilities in Minnesota are all county jails currently, but immigrants can also be held in private prisons. And so this slide shows sort of how it's grown since 1979. So the average daily population in 1979 was 2,300, and now we're at 50,000. And even in the last 10 years, it's grown by about 20,000. So switching from nationally to Minnesota, ICE contracts with 5 jails in Minnesota and then one that's just across the border in North Dakota from Minnesota. Here's a lovely map that I made. Get ready. It's very well done.
Mary, a question that we have is, we talk about immigration detention. Is that any different, the conditions that somebody faces in detention, are those different than what a criminal defendant or somebody serving a criminal sentence would face?
So no, they're pretty much held in, especially in Minnesota, they're held in county jails, and they're held in the exact same conditions as the pretrial criminal defendants and also the post-conviction criminal defendants that are held in those jails. So you can see where they are. None of them are in the Twin Cities themselves. They're all the closest is 45 minutes away in Elk River, Minnesota. Then the average daily population in Minnesota is more than 400. I couldn't find numbers for Candy Ojai, but for Sherburne has a contract for 300 beds, and so they consistently keep that. Nobles County has 2, Freeborn 70, and Carver 21. And then ICE is looking to expand its capacity to detain people in Minnesota. In March of 2019, they issued a request for proposals for up to 600 beds within 100 miles of St. Paul. Sherburne jumped on that and was hoping to expand their capacity to 500 beds. And Core Civic owns a prison called the Prairie Correctional Facility in Appleton, Minnesota, that can hold 1,600 people. And they were also hoping to reopen it potentially with an ICE contract, because that jail is currently closed. But ICE ended up canceling the request for proposals without giving the contract to anybody. But it was reported in August that they could reopen it at any time.
Now, when a criminal defendant is taken into custody, they have the right to ask for appointed counsel to represent them. What about immigrants that are taken into detention? Do they have counsel appointed to them?
No, so immigrants don't have any right to an appointed counsel. They have to if they can find somebody, they have the right to be represented, but they don't have the right to have somebody appointed. And that results in around 30% of people in detention have representation, and the other 70% go it alone. So now we're going to shift into the statutory authority for detention. For those of you who don't practice immigration law, so there's sort of 2 sites here. There's the U.S. Code and then the Immigration and Nationality Act, but it's the same statute. So INA 241A governs the detention of people who've already been ordered removed. People under INA 241A aren't eligible for bond hearings. Same with people under INA 236C, which is mandatory detention of people with certain types of criminal convictions. The INA 236A is the only category of people who are eligible for bond hearings. That's the discretionary detention authority. And then 235B, sorry, that should say 235, not 225. It governs the detention of arriving immigrants, and they are also not eligible for bond hearings. So for people who are in that discretionary category, 236A, the minimum bond that an immigration judge can set is $1,500. And immigration judges currently are not required to take into account the immigrant's ability to pay a bond. And currently the burden of proof is on the person in detention to demonstrate that they are not a flight risk and that they're not a danger to the community.
What is an average amount of bond right now? Let's say somebody's taken into custody and maybe has 1 DUI pending charge, something like that. Would they be expected to get a $1,500 bond?
Oh, probably not. I'm not sure right now what the average would be, but I think it's pretty rare right now to see a $1,500 bond set in that situation. Switching to mandatory detention. A person who has 2 crimes involving moral turpitude, or an aggravated felony, a controlled substance offense, or a firearms offense would fall under 236C. For certain other categories of people who are deemed inadmissible, it's one crime involving moral turpitude, controlled substance offense, drug trafficking offense, 2 or more offenses with the aggregate sentence of 5 years of imprisonment, prostitution offense, or a domestic violence or a violation of protection order. The 2 with asterisks, the drug trafficking offense and violation of a protection order, don't require convictions. for you to be subject to 236C under those grounds. So moving on to the impact. Obviously, people are held in jails, and so that limits the ability of what they can access and what they can do. And as we talked about before, 30% of them have a lawyer to help them gather evidence. The rest of them are trying to gather information to help prove their case on their own. And that results in underdeveloped records and more difficulty in general representing yourself. Or more difficulty for your lawyer gathering evidence because people don't have access necessarily to social media passwords or other types of information that would be usually really helpful in trying to prove up cases. It often results in people taking deportation orders who still have meritorious claims, but when you're facing long periods of detention, some people would rather just be able to get out of jail than fight their case. And then one case that I worked on when I was in law school at the Binger Center sort of demonstrated this situation, which was the case of the Somali 92. My project currently is working with Somali people too, so I see quite often people who were brought into detention at a time when deportations to Somalia weren't happening in effect. And so for a lot of people facing the prospect of detention versus taking a deportation order and getting out much sooner, it was an easier decision there. And so there's quite a few Somali people in Minnesota who have these long pending or long ago received deportation orders who are now facing this situation where they might be actually put into effect, but at the time that they accepted the deportation order, that wasn't the case. And that was the situation for a large number of the people on this deportation flight in December of 2017, or I guess attempted deportation flight, where the US government attempted to fly 92 people to Somalia, but they never made it there, ended up landing in Senegal and sitting on the ground for hours. So people were kept on the plane for almost 2 days, or it was almost 2 days from the time that they were taken from their detention center to the plane and then returned to the United States and returned to detention centers in the United States. And at that point, when they came back, there were attorneys in Florida and here in Minnesota who sort of got involved and ended up filing a Habeas petition to give people on that plane who had claims and who wanted to the opportunity to file motions to reopen and pursue relief that they had previously been unable to pursue. So, I mean, that's a different type of habeas than what we're talking about today, but habeas can be very helpful for people.
So I'm going to go through the case law, primarily Supreme Court case law on habeas corpus, and then get into the leading cases here within the District of Minnesota. So starting off, kind of the modern era of habeas case law was the Supreme Court decision in Vitus, which involved individuals subject to post-removal order detention, so detention under 8 U.S.C. 1231. So these are people who have gone through the immigration removal court process and appealed to the Board of Immigration Appeals, but have a final order of removal. And so the court in Vitus was dealing with cases where people with final orders of removal, despite that final order, the government wasn't actually able to effectuate removal to the country of origin. And so that can happen for a number of reasons, but the court was looking at whether or not somebody could be detained pretty much indefinitely in that circumstance. And they began kind of by reaffirming a few just fundamental principles of due process. Basically the idea that the due process clause within the Constitution of the Fifth Amendment applies to any person, and that includes immigrants, whether they're here in a documented status or not, and whether they have a final order of removal or not. And then fundamental to that right to due process is the freedom and liberty that clause is intended to protect. And so the court in Vitus basically said that in order for detention to be lawful under the due process clause, it has to have a reasonable relation to the purpose for which that individual is committed. And for people who fall under the post-removal order statute, 8 U.S.C. 1231, the primary purpose of that detention is actually effectuating that person's removal. And so the court said that in cases where the government is not actually able to remove somebody, there wasn't that reasonable relation between detention's purposes and the actual detention itself, and that it was no longer authorized by statute and would be unconstitutional if it allowed for indefinite detention. So Vitus was decided on statutory grounds. The court relied on the canon of constitutional avoidance, so they didn't actually reach the fundamental or the constitutional issue there. But there's specific language within Vitus where the court hints that that if this statute, which does not specifically limit post-removal order detention, was interpreted literally to mean that somebody could be detained indefinitely, that would mean that would raise a serious due process problem. And for that reason, the court created this scheme whereby individuals under that statute who can't be removed can challenge their continued detention. And so the way that it plays out in practice is this burden shifting scheme where someone who is detained in post-removal order detention has to provide to the habeas court good reason to believe that there's no significant likelihood of removal in the reasonably foreseeable future. And if they're able to make that showing by providing evidence that there's no travel documents, that the country of origin doesn't issue travel documents, or that they're not going to be able to effectuate removal in their case, then the burden shifts to the government to rebut that showing. And if the government is unable, so if the government is unable to rebut that showing, then Vitus is a really strong decision in terms of the court's language. So the actual remedy under Vitus is release from detention. It's not a bond hearing. And so it is released under conditions that the government can impose. Typically, you're going to see an order of supervision where someone is going to be reporting to ICE periodically and required to update ICE on their address and just do check-ins, but it's released from detention. And then one issue with Vitus is just to limit the number of habeas claims that are raised under this, and as a matter of administrative efficiency, the court construed the statute to contain this 6-month limitation on detention under the post-removal order statute. So the court said that for individuals after they get a final order of removal, there's a presumptively reasonable period of detention that lasts 6 months. And after that time, that's when that burden shifting scheme really kicks into play. There is debate on whether that 6-month presumption is constitutional itself, but that's where the case law is right now. So following Vitus, the next big habeas decision before the court was Damour v. Kim in 2003, which involved a challenge to the mandatory detention statute for individuals in pre-removal order detention. So that's 8 U.S.C. 1226C or 236C under the INA. And so Damour was just a facial challenge to that mandatory detention statute, because under that statute, there's no right to a bond hearing or an individualized determination. So the individual in Damour just said that statute itself and the lack of a right to a bond hearing violates due process on its face. And the court in Damour disagreed and upheld mandatory detention under 236C and distinguished Vitus for two primary reasons. So first, they said that detention under 236C does serve the purposes of detention under that statute. So it was ensuring somebody's presence at the actual removal proceedings. And the big difference between Damour and Vitus in some ways is this focus on dangerousness as a factor for justifying detention. So whereas Vitus didn't really address dangerousness as a reason for warranting detention in cases where somebody can't be removed, Damour is pretty explicit that eliminating dangerousness is a reason for detention under the statute. And then second, unlike Vitus, where detention was potentially indefinite or permanent, the court said that detention under 236C was limited in duration because the statute limits that detention to the time that somebody is in removal proceedings until they receive a final decision. Interestingly, in Damour, the court relied really heavily on statistics that the government provided regarding the average length of detention. And so the government had provided statistics saying that 85% of removal cases were resolved in 47 days, while in cases where people appealed, the appeal process only lasted for a duration of 4 months. So that those statistics that were submitted were false at the time they were submitted, and definitely do not play out in immigration proceedings today. So in a subsequent case that we'll talk about in a minute, the government actually had to submit a letter to the court explaining that their statistics were incorrect.
Paul, on some of the cases that you've worked on now, what is the average amount of time that you're seeing for people who are in custody pre-removal order, so they're going through that process, the Damour cases?
I think, so it definitely depends, but you can see detention ranging over a year up to 2.5 years before somebody's got a final decision. And part of the problem with Damour too is that those statistics are really skewed by individuals who don't have a viable claim to relief and do just accept an order of deportation. But on top of that too, the people whose cases are the most complex and often have the greatest chance of remaining here in the United States are the individuals who are going to be detained for that longer period of time. So the court's opinion in Damour is only a 4-member opinion, and so to get to the majority for 5, you need to read Justice Kennedy's concurrence. And so he was willing to uphold the mandatory detention scheme there, but he did create this kind of carve-out where he said that an individual may be entitled to an individualized determination as to flight risk or dangerousness if detention becomes unreasonable or unjustified. So following Damour, there were a number of decisions within the circuit courts based on as-applied due process challenges. So not challenges saying that the statute outright is unconstitutional, but individuals saying that the statute as applied to them violated their due process rights. So this worked its way up to the Supreme Court in 2018, and in a decision, Jennings v. Rodriguez, which looked at pre-removal order detention again, but it was analyzing detention under 1225B, which is the mandatory detention for arriving immigrants, 1226A, which is individuals who may be released, but it's within the government's discretion, and then the mandatory detention statute again. So the circuit courts after Damour were relying still on Vitus to a large extent, and kind of reading this 6-month time limit into those pre-removal order detention statutes, saying that after 6 months in pre-removal order detention, someone had the right as a blanket rule to a bond hearing. So the Supreme Court analyzed that and rejected that, saying that the statutes at issue could not be read to authorize that 6-month bond hearing rule because there's nothing within the text of the statute that would allow for that. So those decisions had again relied on the canon of constitutional avoidance, but the court said it didn't apply in this case. Importantly, the court did reserve judgment on the constitutional arguments themselves, and so it didn't reach the question of whether the due process clause after a certain point in time does require a bond hearing. And then just this year, the Supreme Court decided Nielsen v. Preop, which was another detention or challenge to the mandatory detention statute. So under 236C, that statute requires the government to take an individual into custody. The statute says when the individual is released. And so a number of courts had read that when released language to mean that if someone was not taken into custody, the mandatory detention statute did not apply to them. And so this would oftentimes pop up in cases where somebody would be in state custody and released, and ICE would not know or be unable to pick them up upon their release. And so these people would reintegrate into the communities, oftentimes establish strong community ties and remain law-abiding. But then when they would be picked up again by ICE, the government would claim that they were still subject to that mandatory detention statute. So again, a number of courts had relied on the canon of constitutional avoidance to say that when released statute or when released language meant that if they weren't picked up, they fell under 236A rather than 236C and did have the right to a bond hearing. But the Supreme Court, again, rejected that reading of the statute and said that unambiguously they were subject to mandatory detention. Still, in Nielsen v. Preop, the court did not address due process challenges on their merits and left the actual constitutional issues to be resolved another day. So there is some language within Preop about factors that could be considered in an as-applied due process challenge. Basically, you're looking at the length of time between somebody's release from state custody and when they're picked up again by ICE. Strong community ties would be important. And then the court said that the likelihood of success in removal proceedings is another consideration. So that kind of leaves us with the question of where we're at following Jennings and Preop. And basically, as-applied challenges are the main route to securing habeas relief and release from detention at this time. So there's a couple issues with this that it creates. It requires individuals to file habeas petitions individually, so you can't make larger challenges to the statute as a matter of facial challenges or statutory interpretation, but you can do individual as-applied challenges. And the courts in these cases are going to primarily look to whether or not the detention remains reasonable. So here within the District of Minnesota, there are a number of cases on detention in the pre-removal order context, and the court has used 6 factors to determine whether or not detention remains reasonable. The leading case on this is a case John litigated called Musa, where the Judge Schultz in that case relied on factors that the different circuit court had used to conduct the constitutional avoidance analysis, but Judge Schultz found that those factors remained viable even after the Supreme Court decision in Jennings. And so those factors are the length of detention to date. That's always the most important factor in any analysis. Second, the likely duration of future detention. Third, detention conditions. Fourth, delays caused by the detainee. Fifth, delays caused by the government. And sixth, the likelihood that proceedings will result in a final order of removal. Somewhat interesting in that there's 6 factors, but it essentially collapses into a 3-factor analysis just based on the way these factors play out here in the District of Minnesota. So the likely or the length of detention to date is almost always going to factor in the detainee's favor if you're filing a habeas after detention has become prolonged. And then the likely duration of future detention will typically favor that too if you're still within that pre-removal order context and there's not a decision from the Board of Immigration Appeals yet. Detention conditions are always going to favor the non-citizen in this case just because they're always held in conditions identical to criminal custody. The delays caused by the detainee and delays caused by the government essentially cancel each other out. Because the court will find that anybody pursuing viable arguments is not causing unnecessary delay. There could be cases when that could be a factor that's considered, but it typically just cancels out. And then the 6th factor, the likelihood of proceedings resulting in a final order, is one that the courts decline to weigh in on, typically saying that it's not their province to consider the merits of the removal proceedings themselves.
Paul, just one clarification a little bit. So when people are talking about this pre-removal order period, what decisions are included within that time frame? Is that just the immigration judge decision, or does it include something else?
No, so it's the immigration judge decision, and then if the non-citizen or the government chooses to appeal, it's the Board of Immigration Appeals decision too. And you can have cases where the immigration judge decides and then the board will remand back to the immigration judge. So it's an entire process until the board enters a final decision. So with here in the District of Minnesota, there's been a lot of success on challenges to prolonged pre-removal order detention. And that is kind of across the board, whether it's detention under 1225 for the arriving immigrants or 1226A, the permissive detention statute, or the mandatory detention statute at 1226C. One issue that we're seeing a lot of is that the typical remedy that the court will order when they're granting a habeas petition here is that they'll remand or require an immigration judge to conduct a bond hearing. So unlike Vitus, where the remedy is release itself, in these cases the court is going to order a bond hearing. And a particular issue with that is that the district courts have not yet been willing to weigh in on who bears the burden of proof at that bond hearing. So whether the government is required to show that further detention is required, or whether the non-citizen is required to show that their release is necessary. Just a few kind of unique and otherwise available habeas challenges here too. So one interesting statutory interplay is that for individuals who have a final order of removal and would otherwise be within that post-removal order detention statute under 8 U.S.C. 1231, if that person appeals to the 8th Circuit and the 8th Circuit issues a stay of removal after somebody files a motion for a stay, then under that statute, 8 U.S.C. 1231, it says that the final removal period does not begin yet, and that the individual is still subject to detention under 236. So it can be either under 236C or 236A. So instead of starting that 6-month time frame after a final order of removal, if there's a stay in place, you're back under the pre-removal order statute, and you can oftentimes have a more viable habeas claim in that sense. There's also a big issue of litigation right now on whether individuals in withholding only proceedings fall under the final order detention statute or pre-removal order detention. And so these are people who already have a final removal order and have been removed, but then returned to the United States without necessary documents and are then redetained, and the government will reinstate that final order. And while normally that would lead to somebody being automatically removed, these people still have the right to apply for withholding or protection under the Convention Against Torture. And so those proceedings themselves can take years to resolve. So there's a debate on whether those people, while they're in that withholding only process, fall under post-removal order detention or pre-removal order detention. 2 circuits have said that they fall under pre-removal order and can have the right to an immediate bond hearing then. Another 2 circuits have said that they're under the post-removal order statute without the right to a bond hearing. But those 2 courts have also said that after 6 months, just as a matter of prolonged detention and due process concerns, that those individuals have a right to a bond hearing after 6 months.
One question. So if a person is successful in getting habeas corpus, how quickly can they be released? I mean, as far as how long does it take habeas to go, case to go?
Yeah. So I think that's one issue right now with habeas, is that after Jennings and after Preop, because individuals are required to file individual petitions, the number of habeas petitions on the docket here in the District of Minnesota has just exploded. And it takes a long time, sometimes over 6 months, to get a decision from the Article III court. And that's for a number of factors, just the number of habeas petitions, but also you're going through a process where a magistrate is going to issue a report and recommendation, and then both sides are going to have the opportunity to file objections to that. And then the district court is going to conduct a de novo review of that magistrate decision too. So it takes a long time, and is something worth exploring whether there's alternative ways to expedite the process.
All right, so I have the fun task of not talking about law or statute or statistics, and get to talk about what it is that we've been doing here individually as attorneys and through the Binger Center for New Americans, and what I hope many of you who are attorneys or in other advocacy roles are able to help us with. Because there's 3 of us. I think we've been practicing law collectively for about 3 years maybe, so we're doing awesome, but we could also use some help. So through the Binger Center for New Americans, American Civil Liberties Union, Immigrant Law Center of Minnesota, and other private partners, private legal partners, we've been looking at trying to develop a really comprehensive and deliberate practice around habeas corpus litigation and immigration. And the goals that we're trying to pursue are increasing individual representation. Right now, you saw the numbers earlier, there's several hundred people in Minnesota that are subject to immigration detention. My guess is there's about 100 who are subject to prolonged detention, who have been detained for 6 months to a year or even longer. There's people in immigration detention in Minnesota that have been there for 2 to 3 years, while their cases are still pending. Many of those people have just sat there quietly without really feeling like they can do anything. But with attorneys starting to step in and take on habeas litigation cases, oftentimes pro bono, this has had kind of a double effect for many of those individuals. First, they're able to have petitions filed in their name to challenge the constitutionality and lawfulness of their specific detention. And that pro bono project has also enabled a lot of other people in detention to file pro se motions or pro se petitions, to file petitions on their own behalf, even without the assistance of counsel, to challenge their detention and get out of custody. Obviously, there is a incredible benefit to having counsel in these cases. Imagine if you're in immigration detention, you don't have, you haven't spent 3 years in law school, you haven't learned all the things that we know, you don't have access to legal research materials, even where they have LexisNexis, for example. I understand it's a 2016 version, so there's no new cases since Jennings v. Rodriguez came out. So imagine trying to write legal briefing based on old law when so much has happened since. Many people don't speak English as a first language, don't have a lot of writing, like English writing skills at the very least. So it's certainly helpful to have counsel in these cases so that people can put their best case forward, to really argue the facts of their case as someone that knows what they're doing. And it also means it helps the court out. It helps the court understand this person's story when they may have to try to piece it together themselves. And it also is just vitally important to have someone in your corner when you're fighting rather than feeling like you have to go it alone. I think as of, about 2 years ago, the statistics that we were seeing for habeas litigation in this district it could be counted on two hands. It was maybe at most a dozen petitions filed each year. Starting in 2018, that number has exploded. There were, I think, 150 that were filed last year alone. I think towards the end of 2017, it got up to about 50 total. Last year was 150, and I think this year we're set to pass 300 petitions filed. The majority of those are unrepresented still, but I think looking through, the number of cases that we've done individually and through the center, I think it's about 30 cases that are represented out of that. So we still have a long ways to go. But definitely, you see even in the pro se petitions, I'll look at one and be like, that footnote looks like it's really familiar. I wrote that. That was copied out of my brief. So the impact definitely goes much further than just the specific case that we have. The second goal that we have is pursuing impact litigation. After Jennings v. Rodriguez, the Supreme Court has really gutted the ability of us to pursue class litigation around immigration detention. Part of that has to do with specific language in the decision. Part of it has to do with the nature of individual fact-based constitutional reasonableness analysis in each of these cases. These are questions that really can't be litigated very well on a class basis, but we can still pursue impact litigation, strategic litigation through individual cases because those do set precedent and do have a major impact elsewhere. So for example, the decision in Musa that I had the privilege of litigating that Paul talked about, that's been cited in, I believe, 12 different districts outside of Minnesota as at least persuasive authority. But basically, it's like the factors that Paul identified are now the Musa factors, and that's what courts are following. I think in 6 different circuits at this point. So a single individual case can have a really huge impact. There are a number of things that I'll turn to in a second, that we are trying to pursue through this litigation, but the Binger Center in particular has really been pushing, trying to address specific issues through kind of incremental litigation to make sure that the whole bond habeas detention process is a lot fairer for individuals. And finally, for those of you that aren't attorneys, this is where you come in. So expanding community support and resources for release. This is something that attorneys can do. We have a role to play in this, but there's so much more that needs to be done. For an individual to get out of custody, oftentimes we're dealing with someone that has a criminal history, mental health issues, substance abuse, may not have strong family ties. It really takes the community coming together to make sure that when an individual is released, that they can be released successfully, that they have a place to go, that they aren't going to get into trouble as soon as they get out, that they're in a strong position to be able to move forward in their life. It also takes a lot of work to prepare for the bond hearing, to make sure that we can put their case forward, show that they're not a danger, really present to the judge who this individual is, what their story is, why they shouldn't just be detained as a matter of default. So it really takes a lot of work to try to track all this material down, to try to find people that can speak to who this person is, people who get to know this person over time. So there's really a role that all of us here in this room can play in this.
John, one thing you were talking about is the advocacy in the habeas petition itself. And we heard from Mary and Paul that often in the Damour cases, the relief is remand for a bond hearing. Is there any advocacy being done in a habeas petition around bond hearings at this time?
Yes, I mean, I think that there's a lot of things that are happening in these petitions. I mean, those of you that are, in law school now or have been in law school, you learn in Civil Procedure 1L, write a very, very simple complaint. Keep it very, very narrow, very short. And that's not really what we do. I mean, every step of the way here, we're advocating to talk about who this person is and talk about what should happen with them in this system. So it really means telling their story. With bond hearings in particular, I assume you're talking about burden of proof. So one of the things that's kind of happened. So a number of courts around the country have started looking at the issue of burden of proof. Right now, under immigration law, immigration judges have to basically have no choice but to hold the detainee to the burden of proving that they're not a danger or a flight risk. This is the only situation in the legal system where the burden is on the person in jail to prove that they should not be in jail. If you think about your own particular case, how would you go about proving to someone else's satisfaction that you're not dangerous or that you wouldn't run away? I've thought about this quite a bit, and I don't think I could do that for a number of reasons. Maybe your situation is a little different, but it's a very unique situation, and there really isn't any flexibility. So if we do get a bond hearing in front of an immigration judge, the immigration judge applies that standard until the law changes elsewhere. So that's primarily what we're trying to do, and I think a lot of it in the habeas field is looking at even in the federal district court where we're filing this, trying to say, Judge, look, if he gets a bond hearing with this burden of proof, this isn't going to be enough for him to get out, and he's still going to be stuck in detention. So, there is no end to this. We're just spinning our wheels here, and we haven't gotten a lot of traction with that yet. And part of it is just kind of procedural stuff, just kind of the nature of federal court litigation. But we are really pushing to try to get that standard shifted in line with the rest of the U.S. legal system and kind of international legal system, where the jailer has to demonstrate why this person should be jailed. Going back to kind of the project to increase individual representation. So the last, I think, 2 years, really, we've been developing a project within the Binger Center for New Americans. All credit is due to Ben Casper, if he's still in the room, for prioritizing that and building that up. It went from me, I think, kind of bugging Ben and saying, hey, you want to do this? And now the three of us are all faculty in the clinic, along with Kathy, and we have a number of students working on cases this year. So this is really ramped up. So in addition to the Binger Center, we have the American Civil Liberties Union of Minnesota on board, thanks to Paul. At least Paul's our kind of representative at the table for that. The Immigrant Law Center of Minnesota, also via Mary. Robbins Kaplan, through some of their pro bono attorneys, and then also local immigration law firms. So Kim Hunter Law, Ojala Barber, a couple of others that have been helping us out with these cases. So through the specific partnership through the center, we filed 6 habeas petitions so far. Those were all, I think, last year, and a couple maybe the year before. Out of those, 5 of those individuals are now out of custody here in the United States. And the only person that isn't out, his case is still pending. We're waiting on a final decision, and we expect that he will be released. So I think this is immensely successful and probably one of the most successful projects in any law school clinic anywhere in the country with this success rate. We're looking at filing at least 4 more within the next month, and I think we're hoping to get our stats up to 10 for 10. So we have a lot of good things coming. And then going back to impact litigation, I mean, this is things that Paul and Mary have talked about kind of throughout. So again, looking at the burden of proof, we want the government to have to prove at a bond hearing that this person needs to be detained, that they've been in jail for 2 years already, that there's a really good reason why they should still be in jail, like why they should be detained for however much longer it'll be, instead of back home with their family. As Paul has also mentioned, the ability to pay. So, think about in criminal court context, if you're applying for bail to get out of custody, the judge is considering what's the absolute minimum bail necessary, if any, to make sure that this person appears in court, doesn't commit any crimes, is a upstanding citizen, basically does the things that we trust him to do while he's out on bail. But it's like, what's the absolute minimum bail or set of conditions that ensure this? In immigration, that's not the case. And there are no set standards in regulation or statute or policy memos as to what bail or bond should be in particular cases. So there's, the immigration judges, I think, use their best judgment, but it's very comparative, like this case to this case. So while the minimum bond that can be granted is $1,500, that isn't tied to any particular set of circumstances. So oftentimes we see even people without criminal records getting $15,000 bond to get out of immigration custody to fight their case. Around the country we've been seeing like $50,000 bond. But without any real rhyme or reason. So that's something that we're trying to address. The Ninth Circuit has issued a decision in a case, Hernandez, dealing with that. But that's something that we're looking at pushing here in Minnesota as well. And then through ACLU in particular, and with assistance of the Binger Center, we've also been challenging county ICE detainers, which the previous panel talked about as well. So Nobles County in particular was picking, and some of the other counties in the state have just been picking people up off the street, driving around and trying to find a county jail where they can dump them off so they can be turned over to ICE, or just picking someone up because they're brown and delivering them to ICE. Nobles County in particular has been going above and beyond and doing things that are blatantly unconstitutional in terms of holding people to give to ICE. So ACLU has successfully sued Nobles County, I think, I don't know how many times now, 2 or 3 times, to put an end to this practice, primarily in state court. So that's something that I think is going to be ongoing. Like the last panel talked about, this is something that's a fight that's far from over. And then going to, again, what the non-attorneys in the room can do. So the Minnesota Freedom Fund is an amazing organization. Linus Chan, is a professor here at the center, who spoke in the last panel, is heavily involved with that, trying to raise bond for people that would most benefit from it in the immigration system. People that maybe don't have a caretaker for their kids if they're detained, people that need to care for a sick or elderly parent, people where detention is horrible for everyone, but people that particularly benefit from being out of custody. Obviously, funds are very minimal, and if we're talking $10,000, $50,000 bond, it takes a lot of money to do that. So all of you should dig deep. When you get your tax returns back, give all that to the Freedom Fund. Conversations with Friends is another really amazing organization here in Minnesota. I don't know if Steve Kramer is still here. There he is. Thank you, Steve, for being here and for everything that you do. They've been really fantastic partners in keeping, providing really kind of like a lifeline to people that are in detention, especially people that have been in detention for quite some time, making sure that kind of having pen pals, when they appear in immigration court, conversations with Friends like rolls deep and brings people to their hearing to make sure that they feel supported. When we've been requesting bond, we've been able to get, character letters from conversations with Friends volunteers about their experiences with this person, their meetings with them, how they've seen this person change and grow over the course of their detention. And it's a phenomenal resource that is very, very hard to replicate in any other way. Recovery and supportive housing is another huge resource. Especially like a lot of the population that we're seeing in prolonged detention are East African or other former refugees, people that came to the United States as children, as refugees from their home countries because of war or other dangerous conditions. And as you would kind of imagine, what they've been through in their life is incredibly traumatic. And like most of us would in that situation, a lot of them have tried to cope with that through drugs and alcohol, or, getting in trouble in other ways. So arranging supportive housing or inpatient treatment, other counseling or medical diagnoses is also vitally important. To show the immigration judge, or to just be able to make sure that when this person is going to get out, that they have a place to go. They have people that are looking out for them and caring for them, and there's a plan for treatment in place, so they can really cope with the issues that are underlying, what may have gotten them in immigration proceedings in the first place. And there's some really amazing organizations and people in the Twin Cities really focusing on dealing with mental health within immigration and within immigration detention that are really worth seeking out. Another thing I think has been very helpful, if you have someone that's been in detention for 2 years, how do you show that they've been rehabilitated from like their, quote unquote criminal past, or that they've, they don't have an employment record during this time. They've just been sitting kind of idly in a jail cell. So it's really difficult to show what they've been up to. Some of the jails here, Freeborn County in particular, actually entrust the detainees to do different tasks, like to basically be employed. So running laundry, being like the librarian in the kind of jail library, things like that. And program staff are oftentimes very willing, if the client has, been a huge benefit to them, or has been kind of a model prisoner, to write like reference letters for them about the work that they've done and their disciplinary record and so on. And very lastly, I think it's important, when we start getting into filing a habeas petition, to also start thinking about how we are going to approach bond. The habeas litigation process has been taking 6 to 9 months from the date that we file. So it is quite a long time, and it's easy to lose track of it, but it is important to start gathering these resources up front and start thinking about what kind of material we would want to have to present to an immigration judge. So it's an opportunity to really start preparing early, because it is very difficult to find things later on. And when we do win our habeas case, generally we win. We have usually 30 days before we have a bond hearing at the latest, as the court orders, but oftentimes that means the actual bond hearing is within a few days of getting the district court's decision. So that doesn't give us very much time at that point to start preparing. So very briefly, I want to kind of touch on like what the responses have been to this litigation effort. I think the district court has been, I want to say appreciative, but they've been very much in agreement with what we're doing and understanding the issues at stake here. Judge Thunheim, who's the chief U.S. district judge here in Minnesota, gave a statement to Star Tribune in a case that was discussing, or in a story that was discussing habeas petitions. He said, in their rulings, or the article said, in their rulings, Minnesota's federal judges, including those appointed by Republican presidents, are troubled by the long detentions and are frequently ordering immigrants released. People have rights, said Chief U.S. District Judge John Thunheim. Detention for long periods of time without a finding by a judge that someone can't be released on conditions is problematic. And I think that this really highlights that this isn't a partisan issue. This is something that affects all of us. Whether you're a Republican or Democrat, the idea that someone can be locked up for long periods of time without due process is immensely troubling, constitutionally, morally, and so on. And I think, honestly, we've been getting our best decisions in habeas cases from Republican-appointed judges, which is not something that you would necessarily expect as we talk about kind of Supreme Court politics. So it's definitely not something to be afraid of. And next, this is, I think, a really, really powerful line from one of the decisions from a case that the clinics, that the center litigated, or a client by the name of Abshir. The Judge Magnuson wrote, the total length of petitioner's detention to date is staggeringly long, totaling 18 months. And that, I think, is like the cornerstone of that decision, ordering him to have a bond hearing. And now Abshir's out of detention, has been for some time, is back with his wife. His child, who was born 2 days after he was picked up on the street by ICE. And he didn't get to see for about the first 19 months of his life. So again, this is, there's so much at stake when we talk about this. And this was from email that we got from Abshir's wife. So you can kind of see there's also a picture of their child attached to it, who was incredibly happy when the wife told him that, or told the child that that his dad was getting out. So it's, it just means so much to people to be working on these cases, to be fighting for them, to give them a lifeline, some hope that they'll finally get out of jail. It makes, just such a tremendous difference in their lives. And then very last, this is, I think, a really amazing case, and really one of the first ones that we did through the clinic. This was originally a client of mine. They represented in immigration court. The picture up there is of him with his wife. So it's Abdi standing there, and then his wife next to him, and then supporters that were, there was like dozens of supporters waiting at the federal building for him to be released out of custody the day that we had his bond hearing. It was just really amazing. I've never heard anyone cheer in immigration court before when we had his bond hearing, and he was ordered released. The judge ordered him released on his own recognizance, which is something we didn't talk about, but you can actually be released without bond. It's the only time I've ever seen that happen, and it was the first time that the judge had ever granted that. So it was a very special situation. So Abdi came to the United States as a refugee from Somalia when he was a child. His basically struggled to fit in the United States. Grew up during a war, got involved with gangs, kind of rose to a very high level in one of the gangs locally. Got ordered removed in 2001 because of some of the things he was doing back then. He got released from custody because Somalia wasn't taking people back then. So he lived on the outside for about 16 years. During that time, soon after he got out of immigration before, he got stabbed in the throat in Minneapolis and was left for dead on the sidewalk. Was in a coma for a month and then came out of the coma to a mom praying over him in the hospital. So he became involved in his mosque. Worked to turn his life around, became really involved in rehabilitation. He works now as a drug and alcohol counselor, and has for several years. Has been very vocal about steering young Somali youth away from violent extremism. Groups like ISIS and Al-Shabaab that have been recruiting locally. And because of that work, he's gotten threats from Al-Shabaab. He's gotten phone calls from Somalia that threatened to kill him if he ever came back. So he got picked up. He has yearly check-ins. He went into his check-in in February 2018. His wife was in the waiting room at ICE waiting for him, and he never came out. So he got detained and was told that he would be put on a flight back to Somalia very, very shortly. Because of all of the community outreach and help from people there and Abdi's own story, we were able to get his case reopened. We were able to get him granted withholding of removal, which is kind of like asylum, not quite as good, but it still keeps him from being sent back. But he was detained this entire time while we were fighting this case. And because, as Paul talked about with Preop, because when released, when you get picked up, when released from criminal custody, in this case meant 20 years later, it meant that because he had been arrested 20 years previously, he was presumptively a danger to the community and didn't deserve to have a bond hearing. He was presumed to be dangerous, and there's no option for him to bond out. And because of a conviction that was also 20 years old, that also prevented him from getting bond. And that's, I think, makes it very clear, what these statutes really mean. It's not just someone that got an aggravated assault a year ago. This is stuff that's very, very old. So he was in proceedings for a couple of months. We won, and the government appealed it to the Board of Immigration Appeals. And even though he won his case, he was still detained. So even though the government had appealed, he was still detained. So think about it in criminal court. If you're acquitted of charges, you get out of jail, even if the government appeals usually. You get to go home, but not in immigration. So while we were waiting for the appeal to go through, we filed a Habeas petition. He got after a couple of months, he got granted his petition and a bond hearing. Right around that time, the BIA dismissed the DHS's appeal as basically baseless. There's no reason for him to have been detained in that entire time. And that was really, I think, the only reason why that appeal made sense was to keep him locked up because there's no chance of them winning. So went back to the immigration judge. His relief became final, and he got a bond hearing and got released on no bond. So, I think, it's an amazing story. It's unique in a lot of ways, but it's also so typical of what's happening with hundreds of people in detention right now.
Yeah, I think that's one of the things, like we've talked a little bit about the person who's actually in detention, and those conditions no doubt are very hard. Yesterday, for instance, I went out with 2 students to the Sherburne County Jail, and we met with a man who had been transferred here from the border. He didn't have anybody in Minnesota, and in fact said that we were the first people to see him while he'd been in custody. He had been able to talk to people on the phone, but he'd been in custody over a year. When we saw him, he was shackled at the feet and shackled at the waist and hands, and so he couldn't move his arms at all. And the reason for that is he had been put in segregation or lockdown because there had been some kind of incident in the pod that he was in. And so I think it's an illustration of just how extreme some of these conditions are in these jails and what people are going through. This man, because he's in this lockdown situation, is allowed out of his solitary confinement cell 1 hour a day, period. That's it. And he doesn't know how long he's going to be in there yet. He hadn't been provided the paperwork yet. So, that's an example of some of the conditions these civil, they're not criminal, they're civil detainees are facing. The other thing that I'd really like to point out is the impact this is having on our communities. And as each Paul, Mary, and John have all mentioned, the clients that we work with are long-term members of the community. Most of our clients have long histories of employment. They've been the primary breadwinner for their family. Many have young children, and it's very common for us to receive calls about, we're losing our house, our kids have to change schools, we can't go to the doctor for some type of medical condition because we need to pay the rent today, or we'll be out on the street. I know we've had one person who actually became homeless for several months with her infant child while her husband was detained and unable to continue supporting her. So, this is having an impact beyond the person detained, even though the person detained is facing horrible circumstances themselves. And with that, I'll open it up to questions.
So I'm a non-attorney, and I know there are a lot of non-attorneys here, so I'm assuming I'm not the only one who doesn't understand this. You were talking about challenging mandatory detention, but it sounds like when you file that petition and you win that petition, they get a bond hearing, but then they get denied bond, so then they're still stuck there, or did I miss something?
Yeah, so that's, I think that's a really important thing to cover, and that's something that we're, I think, really struggling to figure out what to do with as attorneys. So I think out of the petitions that we've won, I'd say the majority have gotten bond or have been released, but a good number have been denied bond. And the reasons for denying bond really, really vary. It could be because the person, was convicted of a violent felony right before they were taken into immigration custody, and that's very difficult to deal with. In other cases, we're talking about like petty theft charges from 5 years ago that makes the person a danger even after they've been, a judge has found their detention to be unconstitutional. Like petty theft charges from like 5 years before they got picked up by ICE. So it's really, really varied, like what, what's being looked at. I wouldn't say arbitrary per se, but there isn't a lot of consistency in how these are being addressed. So I think, that kind of gets into the bond standard question, and I think that that's kind of how we're looking at this is, I mean, in one case, like I had a person that was granted his habeas petition over a year ago, or 13 months ago. He's still in detention while his case is still proceeding, and he had been for 14 months when it was granted. So it's a real challenge. You know, I'm not going to say I have all the answers. There may be a couple other people here that have some thoughts on how to do it, but then we file another petition and try to raise those issues too. But it's tough, and I think that's really the wall that we've run up against, both locally and also nationally in dealing with this.
Paul, I just have a question. To put this in constitutional terms, like, what's wrong with mandatory detention when it goes back down for a bond hearing, that the person's able to get a bond hearing?
Yeah, I think there's a number of issues with not resolving the bond hearing standard itself, so the burden of proof. First and most obviously, you only get this court-ordered bond hearing on a habeas court decision saying that your detention is already unconstitutionally prolonged, right? So the court is already saying it's unconstitutionally prolonged. So it makes no sense to still place the burden on the individual who's detained to show that they shouldn't, that they should not be detained anymore. So it kind of flips that presumption in a way that just does not make sense. But just a couple other issues with it are that so under a normal bond hearing for somebody who has the right to a bond hearing in pre-removal order detention, the burden of proof right now under Board of Immigration Appeals case law does place the burden on the detainee to show that they can be released. And so when the courts don't decide who bears that burden after a habeas decision, the immigration judge's automatic reflex is to just revert to that normal standard that they use. And specifically, the Board of Immigration Appeals has consistently disclaimed any ability to actually decide whether or not the statutes they apply are constitutional themselves. So if you go back down and argue it's unconstitutional to put the burden on me at this point, a lot of immigration judges will say, I don't have authority to consider that issue. And so they automatically just revert to the normal process.
Yeah, it's literally just kind of like a sinkhole in the law that no one really planned for, and then now this issue is opened up and nothing has really filled that in. So it's, you know, the immigration judges are kind of operating in a vacuum and applying the closest law that they have.
Yeah, I will say that it is the failure to decide the issue is kind of, it's not unique to the District of Minnesota, but other circuits will always place the burden of proof on the government after a finding that that detention is unconstitutionally prolonged, and other district courts will do that as well. So there are favorable decisions placing the burden of proof on the government, but so far no district court judge here in the District of Minnesota has done that
Yet.
Yeah, magistrate judges have done it, but they've been overturned. Yep.
I have a clarification. I know you're the moderator, Kathy, but you said something very important, I think, for the non-attorneys here. Can you explain for them the issue between a civil detainee and a criminal detainee, and how immigration, people in immigration detention are not actual criminals, and how that interplays with the lack of public defense and the lack of people supporting them, and why all of this stuff can happen?
Sure. So immigration law is civil law. So when we're talking about 1226 and 12 for a basis of detention, those are all civil immigration detainees. And so under criminal law, if you're charged with a crime, then you have right to appointed counsel. You can't have retroactive laws. Just a number of, there's a speedy trial rule. I think a big thing that happens in criminal court that doesn't happen in immigration court. You know, in criminal court, I can't imagine a single instance of when somebody would be sentenced to a crime that wouldn't know exactly what their sentence is going to be, right? And they're able to calculate precisely when they're going to be able to get out of jail. And that actually, I think, is psychologically helpful to that person in their rehabilitation and in their ability to endure detention and to plan forward with how they're going to act once they're released. And in immigration custody, there is no right to counsel. So the person, as Mary mentioned, has to be able to afford private counsel or be able to find one of the few pro bono lawyers that are available to take a case. And there's also absolutely no idea when you're going to be able to get out of custody. And that has a horrible psychological effect on individuals because you imagine every single day you have no idea, how much longer am I going to be here? Am I ever going to get out of here? If I do get out of here, where will I be released to? And so it's really detrimental to individuals that are stuck in this civil immigration detention without the protections that the criminal law process provides to criminal defendants. I think another really important distinction between criminal law and immigration law, but I think it gets blurred sometimes in this dangerousness context, is what's the purpose of detention? You know, in criminal law, you know, you get a sentence, you're being punished. And in immigration law, sometimes it's, even though that Vitus says it has to be tied to the immigration function, which is removal, this dangerousness prong is applied so broadly sometimes that it's really hard to understand exactly why this person is being detained. Is it really an immigration function, or is it immigration performing some other type of public safety function beyond, you know, a straight immigration role?
And I think, to tag on to that, I think looking at the reason for detention, or like the relation to, between detention and removal, is really important, because we are seeing people in prolonged detention who are not legally removable. Like people that, may have been removable because of 2 criminal charges, but those two convictions have been vacated because their constitutional rights were violated in pleading. So that person cannot be deported, yet they're in immigration detention. In one case, we had a U.S. citizen. In many cases, we've had U.S. citizens in immigration detention who cannot be there. And even after an immigration judge has said this person is a U.S. citizen, they've still been in immigration detention. And so there's very clearly no relation between it. It's either a mix of arbitrariness and punitiveness.
I have a quick question. Immigration detention too, just to, as far as purpose of it, and maybe this is a use more than purpose, but I do think it's being used to wear people down to just give up and agree to be deported.
I just have a quick question about this possible proposed new 600 inmates being held, and the whole thing about public versus private detention facilities. So, there's been the protests in the counties about our counties detaining ICE detainees. And a couple months ago, I met with a couple county commissioners, and if I understood them right, and Steve, you could correct me because you were with us as well, if I understood them right, I thought one of the reasons that they gave was that it's better they be in public county housing than in this private facility, which would have less oversight, less. And so I just wondered about your thoughts on that. Is that a valid reason for our counties to be holding ICE detainees? Is that somehow better than the private facility taking those contracts?
In my experience, I think that counties have become, I think ICE contracts become this important job and money component to budgets and in that way, I think that oftentimes county jails operate similarly to private prisons in that the money becomes very important to their existence, right? And so I don't know, and treatment-wise, I don't know that there's a difference. There are certain standards that ICE sets out in the contracts that whoever's holding them have to comply with. And to my knowledge, there's no difference between a private prison and a county jail.
I
The
think
one thing where it might be helpful a little bit is if you have state laws that provide broader protections than the ICE contract would, then being in a state facility would be helpful. I think that one of the things that Mary mentioned is just how certain counties are making a lot of money off of ICE detention. Sherburne County in particular, they've got a guaranteed contract for X amount of beds every single day. And I think that we need to be smart about how, I mean, the counties are spending that as this is good for our county. It's providing jobs and it's providing income. But actually, a cost is being shifted to the other counties where individuals are being removed from, because our counties are picking up the cost of the children who are being left now with housing instability. I mean, a lot of the other social problems that we see families of detainees experiencing, Hennepin County or Ramsey County or the county of residence is picking up that cost.
And I think it's also really important to understand what, basically understand that the way that immigration detainees are being treated in county jail is different than how criminal detainees are being treated. So, I mean, first, like the criminal jail or the county jails where people are being detained are meant to be short-term pretrial detention. They're not where people are incarcerated after they're convicted. So if you go to prison, you have access to programming, classes, recreation, things like that. If you're in pretrial detention, it's assumed you're going to be there maybe a week, maybe a month tops, perhaps a little bit longer, but it's not meant to hold someone for 2-3 years. None of these county jails, I think maybe with the exception of Candy Ojai, don't have outside recreation. So you don't see the light of day for the entire time that you're in immigration detention. You don't have access to even the same programming that criminal detainees have, pretrial criminal detainees have, like participation in substance abuse or recovery like classes or groups. You don't have access to try to get your GED, things like that. Even, I mean, during the government shutdown earlier this year, we were hearing reports that some of the county jails were refusing medical treatment to immigration detainees because ICE wasn't paying them for that. That's not something that they could deny to criminal detainees. So criminal jail county jail is, I think, very different if you're a non-citizen in immigration proceedings versus if you're a defendant. And the private facilities have a lot of their own issues. I think morally it's incredibly offensive to be jailing people for profit, but a lot of those facilities do have the ability to provide for recreation and other programming. So I think that it's a lot of trade-offs, but I don't think, neither one is good. The best alternative is not have people in jail in the first place, and after that, there's trade-offs.
Yeah, I think that some of the people that we see taken into custody have pending criminal charges. And so at the time that the judge in the criminal case is releasing that person, they're going to order them to do something usually. Usually it's a report for some kind of reprogramming, be under probation. And so, that's like a state interest. The state has an interest in seeing that this person is on a path to returning to law-abiding behavior. And when ICE kind of swoops in and takes that person into custody, they're cutting off that ability of that person to enter into this programming that the state has a desire to see them complete. And when you think about the number of people that actually are going to be held in immigration custody for long periods of time and be released back into our communities, it really seems obvious to me that this is against broader public policy.
I have a question. I'm wondering with all the immigration judges are in kind of a weird spot now. They're not, we think of them as being judges. They come in wearing black robes, but we all know that they work for the Attorney General, and that's never been more manifested than I can remember in my history than now, where the Attorney General is limiting how they can administratively handle their cases. The immigration judges aren't happy about that. They filed a grievance. In response to that, the administration is trying to eliminate the judges' union. So the vibe that one gets from looking at this fight is that this group of, quote, judges, unquote, may not be as independent as one might hope they would be. And I'm wondering, what's your perspective on how federal judges, who really are independent, how are they reacting to this, and how would that be influencing, do you think, their decisions on questions like bond determinations and whether or not the immigration judges are acting sufficiently independently or whether they're just acting as hacks of the Attorney General?
I mean, I would say that there is a difference between the federal judges and immigration judges. I mean, for the habeas cases, I mean, the vast majority of these are decided on paper, so there aren't, in-person hearings in front of a judge. And I think, the judges haven't really weighed in too much about what they think about the immigration system as a whole. In general, it's very limited to the specific issues of detention. But I will say, so when I was, we were litigating Musa, so as his case was going through the district court, Jennings came down, and Judge Schultz ordered a hearing on the petition to try to sort out post-Jennings issues. But from the date that he scheduled it until the hearing, it was about 3 months. 3-month difference. When we got to the hearing, the first thing that Judge Schultz said to me was, "I'm so sorry that we couldn't have this sooner, that we're making your client wait even more. I know that it's really difficult for him." And honestly, that's the first time I've had a judge, practicing in immigration court or in federal court, the first time I've had a judge acknowledge that my client is actually struggling, that this is actually tough for them, and it's not just oh yeah, you're just in jail. Actually acknowledging my client as a human being, that that detention is, really takes a toll on them. And that was, I think, really remarkable. I think it's also very much Judge Schultz, but I do think that there is, the federal judges have a very different perspective on this than immigration. I mean, they're hearing criminal cases as well. They're dealing with federal habeas petitions. They deal with a lot of different civil rights issues, and they're seeing lots of other types of immigration cases. So delayed adjudication, wrongful deportation, unlawful denials of naturalization and things like that. So I think they're coming in with a very different perspective, but I think they're able to appreciate what's happening from a very strictly constitutional standpoint.
Yeah, I would just add too that I think we're seeing a real willingness from the federal judiciary to push back, especially at the district court level, on just prolonged detention in general. So in any habeas case that's filed, especially cases like mandatory detention under 236C, the government always argues that the statute means literally what it says, that somebody can be detained without a bond hearing until they get a final decision on that case. And they've stuck with that argument for a long time, and no district court judge here in the District of Minnesota is buying that right now. And in other contexts, the government will raise similar arguments that have been rejected in other courts, and it's consistent pushback from the federal judiciary. I think the next step kind of is a case where there is a habeas grant and somebody remains detained after a bond hearing following that habeas, and then it ends up back in front of the same judge.
And I think that that's the direction that we're going in, and I think that there is definitely frustration on the part of the federal judges. And we had a decision about last month that just flat out said the government's position in all these cases is ridiculous and without any merit. So I think they're getting a little tired of this. These cases are 20% of the court's civil docket right now, of the U.S. District Court. 20% are immigration detention cases. As best as we can tell, it's taking up a huge amount of time and resources, and the arguments are it's boilerplate briefing back and forth on the exact same issues. It's already been decided, and here we are. But we did have one judge that was starting to get a little bit more annoyed. In one of my cases, he was granted a bond by the immigration judge, and I still refused to release him after that. And the judge was not happy about that, and as soon as the government kind of figured that out, they let him go very quickly. So.
Awesome panel. I have some very quick questions. One, are you seeing pro se petitioners win? 2, are you distributing pro se materials, which maybe you said that and I missed it? And 3, is the government signaling that they're going to be appealing any of these?
Can you answer that? So I guess if I remember the order correctly. Hi, Becky. So yes, pro ses have been winning quite a bit. kind of general rules of like pro se litigation, it's construed pretty favorably. The law is pretty settled. The judge figures out what authority the person's under, how long they've been there, and then that's, that kind of takes care of it. And really, have 1 minute. One of the first cases that set the stage for this litigation was pro se. We haven't been distributing materials, but I mean, they have been getting them. We send our clients materials and they get copied pretty, pretty widely. What was the last question? What was your last question, Becky?
Appeals.
Oh, yeah. So the government's appealed, I think, 6 or 7 of these to the 8th Circuit. They withdrawn all of those appeals. So they're appealing them up to just keep the door open, but they're not pursuing it yet.
So there was the one case to reach to the 8th Circuit too, the Ali v. Brat case. But that ended up in an unpublished decision, and the court didn't reach the constitutional issues again. Yeah.
I think we're out of time.
You didn't give us any warning.